Well, we all know Hillary Clinton spent 3.5 hours with FBI investigators today in Washington, D.C. It's a meeting that's been weeks in the making as we wait to find out exactly what happened. Let's talk about what's next. Here to shed some light, E.J. Apt, a criminal defense attorney based in Atlanta. Thank you so much for joining us, sir. We appreciate it.
Thanks for having me.
Some of our viewers, of course, as we wait to find out exactly what the findings, the conclusions are, they want to know what is the possibility, what type of punishment could she be facing? What could happen next?
Well, I think it's important to parse out the politics from the law.
Right.
If we just look at the law for a second and put the politics aside, there's really two statutes in play. There's the executive order that the Obama administration has on classified information, and separate from that, there's the Federal Records Act. The executive order essentially would, if properly analyzed, show that Hillary Clinton broke the rules. It's a rule, it's a policy, it's not a criminal law per se, so she could be found as having broke the policy by having a private email server, by not securing classified information. In terms of the Federal Records Act, there's got to be an intent to really leak or distort classified information in such a way that raises to the level of her intentionally breaking the law to disseminate classified information to parties that are not supposed to have it. So that becomes a very difficult thing for the FBI or any prosecutor to prove, because even if you show she had her own email server, even if you show she mishandled emails, even if you show she wasn't taking proper precautions, it wasn't as though she intentionally leaked.
That's what I was going to ask you. How do you prove intent?
You're not going to, and so then you shift to the political reality. And the political reality is that no one in the Obama administration is going to indict Hillary Clinton. The FBI director reports to the Attorney General, who reports to the President. It's a non-starter. If someone other than Hillary Clinton were to become president, you might have an indictment, but I'm not sure it would stick. The best possible outcome would be if Hillary actually becomes president, then you might get an independent counsel appointed by Congress to investigate her and prosecute her. It's still going to have a tough time making it stick. It looks and feels and tastes a lot like Whitewater from, a generation ago. But theoretically, if they can prove that she intentionally leaked classified information to parties that she knew did not have that clearance, she could be guilty of a federal felony and face, 20 or more years in prison. It's a serious criminal offense.
I want to ask you a question because I have heard pundits make analogies, and they have said that this case, and they've drawn the analogy to General David Petraeus, of course, the former CIA director, who pleaded guilty last year to mishandling classified information. Do you think that's a fair analogy at all?
That's a really good point. I don't know that it is particularly fair, because Petraeus actually took pieces of classified information that had active, ongoing combat strategies and leaked them to a reporter, to an actual journalist who was doing a biography on him, who he was, obviously having this affair with. But
so what I'm understanding is you're saying intent could be proven there.
Yeah, I think there's more of an intent there, because he knows that that's actionable intelligence, and he's giving it to someone who's at least in name, in the press.
But if Hillary Clinton knew that she had her own server, which she knew perhaps was unprotected. Yeah,
and I think that there are clearly some advisors she was consulting that she knew did not have security clearance. But she was from the emails, if you actually sit down and read them, it looks like she's asking them questions about strategy and political advice, and she's not necessarily leaking actionable confidential information. So there may be a distinction there, both in terms of the law, substantively, and the intent. It's not as though she, leaked information to the New York Times and said, hey, I want you to know, here's what's going on in, on the ground in Afghanistan or something like that. So I think there is sort of a difference there. But again, if we're really talking about fairness, maybe the best thing that could happen if she becomes president is an independent counsel gets appointed, let that person investigate, let that person use their prosecutorial discretion and decide, do we present this to a grand jury or do we not?
Well, E.J. Apps, we could pick your brain all day. Thank you so much for joining us, sir. We very much appreciate it.